do each year with the Arizona School Boards Association and the Arizona School Business Officials, kind of bring you up to date on what happened during the legislative session. As you'll see today, there's an awful lot of bills that we're going to cover. We'll move through them as quickly as we can. But one thing, we will have time for some questions at the very end, but we'd appreciate it if you limit the questions that you might have to those that are of a general nature, so they would pertain to everyone who is in the audience. If you have some specific questions that are unique to your district, you could either contact Janice Palmer or myself or the Department of Ed, whoever might be appropriate to answer that detailed type of question. Before we actually move into the webinar, we just want to have a moment of silence for the 19 firefighters who died yesterday fighting the Yarnell Hill fire. Our hearts and prayers go out to those families and friends of those people. What a tragedy for Arizona, and it shows how important those first-line people are to our state and how tragic things can be. So we'll just take a moment of silence and then we'll start back up again. Okay, thank you for honoring their service. I also want to thank E.J. Nicely, who's doing the technical support for us today. As we've said many times, without Ernie, these would fail for sure if you were depending on me to do it. So we do appreciate Ernie and all of his help. And now we will start our webinar. First thing is Janice Palmer talking about the effective dates for the legislation.
All right, thank you and good morning. For the fiscal year 2014 budget, as you saw, this was the last item that needed to be completed from the legislature. Two things to take special note of is that there are different general effective dates for the budget. The first one, the feed bill, the general appropriations bill, this is the stuff that we'll talk about for the per pupil funding, school safety funding, those items. That bill becomes effective right upon the governor's signature. So June 17th, 2013 is the effective date for that. The policy implications that are also included for K-12 education is in House Bill 2003. The policy implications, things like the bonding and some of the other items that Chuck will go into, becomes effective as of September 12th, 2013.
Okay, now we'll start looking at budget provisions that were passed during the special session, which was ended right before the regular session ended. I believe the Department of Education and the Auditor General have their forms out, and people are working on their budgets. I see in the paper where some people have proposed and even adopted their budgets. But we want to review this with you and share some of the background information that we might have. The first thing is that the base level for next year is set at $3,326.54. For those budget people out in the school districts, you know there's that number, and then there's the number with teacher comp included. And with teacher comp, that number is $3,368.12. That's a 1.8% increase. A little background on that, the School Boards Association and a couple of other education organizations filed a lawsuit a while ago because the state was not funding inflation factor for the base level, which was the real important part of Prop 301 when it tried to have inflation funding for schools. That lawsuit has been moving through the courts, and it's currently with the Supreme Court now. The state's appealing the ruling that was made, and hopefully that'll stay. But basically that is an $82 million increase for the last couple of years, and it'll be again for next year. Transportation also gets a 1.8% increase, and the additional assistance for charter schools gets a 1.8% increase. The only thing that the legislature had not done for the last few years is increase the base level. This year, they did include that in their legislation. They didn't go back and fund inflation. If you go back to the first year they didn't fund inflation in the base level, we're probably looking at a 5 or 6% increase, but that was not part of the lawsuit. But hopefully the Supreme Court will have a positive ruling, and this will continue on to help school districts. There's $3.65 million that was appropriated for school safety. There's some provisions with that. The 25% of the money appropriated has to go to security hardware. There's School Readiness Pilot Program. It's important for you to note that this is in addition to the Prop 301 money. I think that's $7 million that's been going to school safety for many years. So this is on top of that, and the Department of Ed and the State Board of Education, I imagine, will get information out to you on how that works. Now we'll go to the next slide.
And also included in the budget is $2.4 million to the Performance Incentive Fund. If you remember when the governor first came out with her proposed budget, she talked about including monies for performance funding based on the A3F accountability system. So this is school-wide district performance incentive funding. And the $2.4 million that is included in the budget is really a placeholder, because I want you to take special note that no monies are expected to flow. There's no actual system or formula yet in place. None of these monies look to flow until fiscal year 15, and that was on purpose. And talking with the governor's office, they plan to meet with various education folks in order to come to a conclusion on the best way to have that formula that incentivizes schools. And we can also tell you that the initial proposal of 50% on static performance and 50% on growth, that's pretty much off the table. There will be quite a few changes, things like rolling averages, things like a different percentage amount. I know that both Chuck with ASBO and we with ASBA have been working very hard to make sure that it's a fair system so that everybody can achieve that money. But the big thing to take away is that no monies will flow. There is no formula until fiscal year 15.
Okay, the next thing we'll talk about is the change in Coral and soft capital. Probably the best way to look at that is what the legislature did was they eliminated soft capital that's taken out of the statute, and they basically converted what was the Coral statute, capital outlay revenue limit, to the new district additional assistance program. So the new district assistance program operates a lot like the old Coral program. It also has the growth factor in there that if you grew by more than 5%, you get to add some additional money, only they did modify that before. If you grew by more than 5%, you got to take all of that growth above 5% and add it into the formula. The new provision only allows you to take 50% of the growth, so it has less growth capacity if you are a growing district growing by more than 5%. And it also has the same provision that Coral had with the new district additional assistance, that you can put it into operational or capital or mix it between the two. A couple of things that districts will have to do is, since soft capital has gone, something has to happen with the monies that are left in that soft capital fund. And basically at the end of fiscal year 13, districts have to take the cash that's in that fund and move it to M&O or to unrestricted capital, and also take the capital capacity that remained in soft capital and move it into your operational budget or to your capital budget, or share it between the two. Again, that new fund's going to operate a lot like the Coral Fund operated before. Next slide. We'll talk about this a little bit more. I'm sorry, it's always good to have Janice here to correct me when I miss something. But those of you who know me, I do those things on purpose so that I give her something so she could feel important about. But I did miss that last item there, that JTEDs, and we'll talk later on about some of the Joint Technological Education District legislation. They did very well this session in terms of some of the things that they wanted, and they did get those items through. You'll see as we go through our report this morning. But basically, for the last few years, the Joint Technological Education Districts were all funded at 91% of what their formula funding would prescribe for them. And for this upcoming year, that does change, and that 91% adjustment will only be for the JTEDs that have more than 2,000 students, which I believe are the three largest JTEDs. All the other JTEDs will now move to 100% funding. Now we'll go to the next one. I do appreciate Janice for picking that up. This one we'll probably talk a little bit more, but we'll cover some of it now. Permanently increases the elementary and high school district Class B bonding capacity limits from 5% to 10%, and for unified districts from 10% to 20%, which now districts have a bonding capacity that's equal to 2/3 of what their constitutional authority has been, where it had been reduced to only 1/3. It'll apply to bonds pursuant to elections held both before and after the effective date of this legislation. There's a referendum process that's in place, and we'll probably talk to you about that a little bit later, that could affect the implementation of this section of statute. And then by November 30th of each year, something new that the legislature is requiring the Department of Education to submit to the Joint Legislative Budget Committee and the Governor's Budget Office a report that lists the amount of money budgeted by override type for each district for overrides. And the last item here is a really good thing that the Governor's Budget Office, the Joint Legislative Budget Committee, Lyle Friesen, and the Department of Ed all worked really hard with school districts to get this implemented, and it basically doesn't change the concept of the rollover. Basically, the rollover is still there for the majority of districts, but it does make some changes that will help, especially smaller school districts, and basically reduce the K-12 rollover by $21 million. And the reason for that is that there'll no longer be any rollover amount for districts that have fewer than 600 pupils. And then for the rest of the districts, you're going to still have the rollover amount, but it's going to be easier to calculate, because instead of taking some out of some months and a different amount out of other months, basically they'll make it uniform throughout the whole year and take a little bit out of each payment. And the biggest thing is that you'll get your money that was rolled over a lot more quickly than you have in the past, because by July 12th, the state has to pay you all the money that they owe you from the rollover, so you won't have to wait as long to get that. And we do thank Lyle and the Department of Ed and budget offices for working on that.
And I'll also say that on that, Chuck was very integral in working with Treasurer Ducey's office as well to get that done. So that was a definite team effort and something good for schools.
I did. Thanks, Janice. I did forget to mention the Treasurer's office. They were helpful on this also, because they could have nixed it if they said, no, there's not money there, but they were very supportive of this concept also. On the next slide, for the Department of Ed, for their data system, they've asked for more money and basically made a pretty good case for the additional funding that they need, but the legislature basically is funding them at the same level for next year that they were funded at this year. It's $7 million. Part of that is the appropriation from the legislature, and then there's $1.6 million. If you remember, a couple of years ago, the community colleges and the universities were required to pay money to the Department of Ed based upon their numbers of students. And when you add those two things together, there'll be $7 million there for the new data system at the Department of Education. School Facilities Board, as we mentioned in an earlier slide, the building renewal formula, which had been suspended for a number of years, is now gone. It was repealed. In place of that, they're looking at a program that will have a building renewal grant program. The legislature appropriated $14 million, which a lot of people feel probably is not adequate for the building renewal needs that school districts have identified, but they will be $14 million there, and it'll be a building renewal grant program. And there's some new requirements for the School Facilities Board that they're given the task of inventory and inspecting school buildings and developing a database to administer the building renewal grant program and the new construction program. And they did make a change in your timelines for submitting information to the SFB. Now that information will be required by September 1st, where currently it was October 15th. New school funding, and if you're a district that is growing and expects to, over the next few years, to have some money for new buildings coming from the SFB, you probably need to contact them to see the details of how this works. But basically, the big change is no longer will you get money based upon what may be coming in terms of students to your districts. You'll only be funded for the students who are actually there, and if you don't get approved by the spring of the year before, then by March 1st, then you're not eligible for any money in the subsequent year. So it changes that process quite a bit. I imagine at one of our ASBO meetings we'll have the SFB come and provide a little more detail on that. And the last thing requires the Department of Ed to transfer $10 million, which wasn't used from the Arizona Structured English Immersion Fund into the State General Fund.
And now Jeff Esposito is part of the government relations team and also spearheads our advocacy efforts. And you've seen his work not only in the advocacy efforts, but initially at the beginning of session, the extensive brief that shows all of the legislation affecting education that's come about. He's done a lot of hard work on that, and we're happy to say the #1 item on our website to be looked at. And without further ado, Jeff?
Yeah, so as Janice mentioned, back towards the beginning of the session, we put out a comprehensive brief of all education-related bills that have been filed in both the House and Senate. And now that the session is over, we've gone back over that comprehensive brief, updated it, and reorganized it so that it's a little bit easier to read. You'll find a few separate sections within it. First, you'll find the bills that were signed by Governor Brewer, along with their chapter numbers and all their final provisions, and the bill sponsors as well. You'll find a list of the vetoed bills, bills that failed in either committee or on a vote in the floor of either house. And you'll find bills that were lost in the process and bills that were never heard in committee. That will be up on the website immediately following the webinar here, so please feel free to check that out. It'll be a PDF. It'll be completely searchable. And if you have any problems or any questions, please just feel free to email or call me. Thanks.
Jeff did a great job on that, and we can't reiterate enough. Please look at that as kind of your resource. Even the bills that never had a hearing, many times we will see them again. And that has all of the information that you need on the bills, because in the webinar today, we're just going to focus on key legislation that passed and give you an update on those items. But if you want the comprehensive, go to ASBA's website and see what Jeff put together. So on to key legislation. The general date of all of the legislation that we're going to be talking about is September 13th, 2013.
Janice, could we do? Would you mind if we did one thing in terms of, we have a poll that we wanted to take, and we wanted to wait till we got enough people registered to look at how many people are actually participating in this webinar at the different locations. So if it's okay, let us take a minute or two and just do that poll, and then we'll have that out of the way. Okay, well, thank you. I'll have to pay a price for that, but that's part of our jobs. Okay, Ernie?
Yeah, it's up there now. People are now responding. That's what they see on the screen.
Okay, on your screen you'll have the poll so we can kind of see how many people are at each location viewing the webinar. This will help us for future planning. Okay, we have a few more who need to vote, and then we'll go on with the webinar. Okay. All right, thank you for sharing that information with us, and it's back to Janice.
All right, so for the key legislation that passed this last session, we'll go over those. The general effective date is September 13th, 2013, unless there's an emergency clause included, and we've tried to articulate if there is, in fact, an emergency clause included in them. The way that we've organized it is in numerical order by chapter number. So as we go through there, you can kind of see why the House bills or Senate bills don't necessarily follow numeric. We did it by chapter number. So the first bill that went through, it feels like almost a session ago. It feels like we almost had 2 sessions this year. Chapter 10, House Bill 2427, Schools Unification Consolidation Initial Meetings. Basically what this bill has to do with was that there are school districts that were looking to unify and or consolidate. However, the current statute and the way that the dates were working didn't allow the Unified School District Governing Board to actually take action and be its own entity. So this bill allows that to happen, and it also allows the unified boards that can't meet the current deadline to preliminary file the new taxing district information. So this is specifically for a few districts that want to embark on this and just were impeded by current statute, and is retroactive as of June 30th, 2012.
Okay, the next piece of legislation, House Bill 2071, was requested by the Department of Education, and it's a good thing to happen. A number of people, when they went to the Department of Ed and had to pay for certain licenses or to pay for certain charges, weren't able to do that, and now they will be able to do that with a credit card, debit card, or other electronic payment, and the Department of Ed will just add a convenience fee like a lot of people, so they have the capacity to process those. So that'll make it a lot easier for people to get things from the Department of Ed, and good deal from the Department of Ed.
Next bill for education, Chapter 20, House Bill 2425. The short title is a little bit misleading now because the biggest part of this bill, frankly, is the first item there in addressing the assessment issues related to Ames and Park. So the first item, it removes the requirement that the state board develop and adopt competency tests for high school graduation. And the big issue behind that is to develop and adopt. This opens the door for us to be able to be part of the consortium, as we currently are with Park, to deal with the new standards that we have adopted into 2014-2015. The other item is it repeals the requirement for a norm reference test. If you remember, Ames is now duly done, serves two purposes. One, it gives a competency-based score in Ames, but it also is a norm reference test that satisfied the Stat 9 issues. So that has been removed. The plan is, beginning in 2014-15, that we will just move to a Park end-of-course exam and no longer have any kind of norm reference issue. The other item is it eliminates the current Arizona English Language Learners Task Force. That is now all directed to the State Board of Education. And interestingly enough, it's retroactive as of December of last year. So it still keeps in place any of the decisions that were made by the English Language Learner Task Force. However, now all responsibility now lies with the State Board of Education. And I know that they are currently working on some of these items because with the Flores case remanded back to the Ninth Circuit, they're now trying to figure out how to deal with the litigation as well as the new responsibilities that the board's been given. Next bill is Chapter 29, 2476. This is about isolation rooms, and this requires governing boards to develop policies in this next school year for confinement as a disciplinary measure. Want to be very clear on this because this bill went through a number of amendments, that this is dealing with general population kids, so all kids and any kind of confinement issue that would be in an isolation room. And it requires a process for prior written parental notification in the student's enrollment packet or admission form. And if there's some disciplinary measure that schools could not foresee, it allows for a parent then to be provided that information in a reasonable amount of time, but that process needs to be articulated in policy as for how the district will move forward on that. This issue is not going away. There are plans to be an ad hoc committee to deal with the special ed side of isolation or restraint seclusion, but this one just now deals with general population kids. Ad hoc committee, this interim on seclusion restraint. This does contain an emergency clause, which means it was effective upon its passage. Next bill, Chapter 68. This is kind of a pretty significant piece of legislation about charter schools and applications, renewals, revocations. The Charter School Association actually had received a national grant to take a look at how we authorized charter schools, how we did renewals, and to increase some of the accountability issues from that. And that's where this piece of legislation came from. So there's numerous changes on it. The specific items is now that any charter provider needs to have a detailed educational, business, and operational plans and anything else that the sponsor is requesting. But it removes the requirement about governance issues, personnel policies, those items. It's really focusing more on outcome-based, both educationally and financially, for the sponsor and the charter authorizing board to determine whether that is in fact a good plan or not. It does reduce the time frame for notification of intent to revoke and for a charter to improve performance from 90 days to 60 days. Again, I think this is an effort for some heightened accountability if the school is not performing. And the other good part of this bill is that performance framework, what the charter is actually proposing to do, as well as the performance that they're actually making on their charter, must be publicly available on their website. It exempts the Board of Charter Schools from rulemaking for 2 years to comply with some of these changes. And also, this contains an emergency clause, so it's effective upon passage. But this one has some pretty significant changes for charters. And again, a lot of it to really try to heighten the accountability.
Okay, next bill is House Bill 2170. I'll just give you a little bit of background on this. A number of years ago, there was a student who was killed getting off a school bus on a private road, and that brought up the issue of whether buses are required to put out their stop sign and put on their lights. This bill went through the legislative process. A lot of discussion took place, but basically it makes it clear now that a school bus operator must display the stop signal and the flashing lights on a private road or driveway when they're picking up or discharging students to and from school routes. I know Dean Humphreys, representing ASBO, and a number of transportation directors worked with the legislature to kind of get the language on this so it was workable, and that's House Bill 2170. Okay, on this bill, House Bill 2042, it's a voluntary program to make it more workable for districts to provide services to students who may need insulin or glucagon. Is that right, Janice? Janice told me how to pronounce that. With self-administration of insulin in an emergency situation, it adds nurses to the group of health professionals that can train people to do that. Again, it's a voluntary program, but it gives districts more options in how they administer those services to their students.
Next bill, Chapter 88 on elections and public resources. This is one of those that is always, this is a piece of legislation that's always a good reminder that one incident at a school can create legislation for everyone. And so we seem to be having these election resource bills the last 3 years in a row, and this is the latest one, prohibiting the state's political subdivisions from using public resources to influence an election. We worked and were able to successfully ensure that district governing boards still can submit pro-con ballot arguments for overrides and bonds. That was an issue that was not in the original bill, but it is still allowed under the current legislation. It provides a definition of what a government-sponsored forum or debate is, as you can see there. So that's to ensure really that if there's nonpartisan or equal opportunity provided for persons to engage in the discourse, that is still allowed. In essence, most of the items that are in this bill are codifying the Attorney General's opinion about what is and is not allowed in 15511. But this is one that you're going to want to see in your policy updates that Chris will talk about a little bit later. I think the significant issue is that there's a huge increase in the civil penalty if a person knowingly violates any section of this. It's now $5,000 per incident rather than the current $500. And we have had a couple of persons assessed, so please keep that in mind. It also allows the court to order an additional penalty for any resources that were used that were not lawfully allowed to do so. But for the most part, we've been able to clean up that bill so that that should not create a significant change in what you are doing as far as 15511 policies.
Okay, next bill is Chapter 91, House Bill 2202, school district leases. This is an example of a lot of school districts and education organizations working together. The Kyrene School District and Jeremy Callis kind of took the lead on this. But basically, it now allows school districts to enter into leases or lease purchase agreements for school buildings and grounds for a longer period of time without an election. Prior to this change, it had to be a maximum of 5 years or it had to go out to an election. This allows 10 years to have those lease purchase and lease agreements in place for school buildings and grounds. And there was provision in the school plant fund that school districts were not allowed to call for a capital outlay override while they were using the proceeds from the sale or lease of school property, and that's now been removed, so it gives districts more flexibility in terms of how they can use that existing money and still be allowed to call for a capital outlay override. Next bill.
And I'd also say on this piece of legislation, I think it shows it was a great partnership too with the core construction folks, really kind of doing a good partnership with the school folks to make sure that this legislation met everybody's needs. So we appreciate their efforts too.
That's a good point. And a lot of the issues that deal with bonding and provisions of bonding, we all get a lot of help from the different companies that provide consultation services to districts to help get the language correct and help us get some things through that benefit and make it easier for school districts to operate. The next one is Senate Bill 1293. There's quite a bit of misunderstanding on this. There's a number of people who thought this was related to the governor's performance funding plan, and it really isn't. It's a different concept. It's basically a pilot program that would look at how you distribute money to school districts in a different manner. The sponsor of the bill uses the issue a lot. Well, we provide funding to school districts in this state on seat time, on the amount of time that students spend in a program, and this is an attempt to see if there's other ways of funding more on what students learn and what students achieve rather than just strictly on seat time. So it's a pilot program to try and do that. It can have up to 5 districts and 5 charters. One of the sponsor of the bill also talks about maybe not funding overrides and things of that nature and putting all of that money into part of a funding formula. But the main thing is to see if there's a different way of funding schools that doesn't rely so much on the time that students spend in a program, but more on what they get out of that program. The next one is Senate Bill 1170 and this is for the Arizona State retirement system. A couple of things that it does. The first one, there was a provision in the law that basically, because we're a community property state, that required individuals to list their spouse in certain situations and not have flexibility, that this bill now does allow. That basically it says that there's certain things you don't have to do if there's another law that prevents that from happening, or there's an existing contract or a court order. So it allows people to make some choices more consistent with other laws and with what the courts may already be requiring. The second item there is, if you remember when there was a big newspaper articles a few years ago about the state retirement system and what people were making, and it raised an issue with the retirement board of what do they have to release as public information. Excuse me. And this basically clarifies that. There's certain things like Social Security, health insurance records, email addresses, medical records, individuals' addresses that they don't have to release. They would have to release things that are related to the funding of how much the person earned and things like that, but they don't have to release a lot of the personally identifiable information. The other thing it does is eliminate the permanent benefit increase. That's really the cost of living increase that was put into the retirement system a number of years ago, which hasn't been funded for many, many years now and probably won't be funded for a few more years at least. And this just says for new members coming in, that formula for a permanent benefit increase based upon the earnings in the retirement system is not valid. It only affects new people coming in, not people who are currently in the system. And the last item is it allows the state retirement system to start and implement a self-insurance health program. When you talk to the staff at the retirement system, they have no plans or interest in doing that at this point in time, but in the future, if they ever wanted to, it gives them that authorization.
Next bill, Chapter 132, establishes the Extraordinary Educator Special License Plate. So another license plate that, with the intention of, well, let me back up. So it establishes the Extraordinary Educator Special License Plate upon an entity paying $32,000, and it creates this trust fund for a specific foundation that's also defined in law. So what the plan for this is, with the first $32,000 initial startup, then anyone that wanted a license plate would pay the $25, of which $17 would go into this fund. And the plans that the foundation has for the fund is to give grants to teachers on specific innovation items. So the first issue is they need to come up with the $32,000 for this to be implemented. The next bill, Chapter 147, this is similar to a bill that was passed for school districts about 2 years ago, allowing an enrollment preference, this time for charter schools, for grandchildren of employees of the school or charter holder, and you can see the various folks that would be allowed into or given a preference into that charter school. And it also allows for an enrollment preference to a student or the siblings of a student that previously was in a charter school that has the same organization, management organization, or provider that's there. The next bill is Chapter 148. This is also a similar bill that school districts saw last year from Representative Mesnard. It basically allows charter schools, the same as what school districts are allowed, that they can be exempt from certain rules and statutes that the State Board of Education will determine if that school has maintained an A for 2 of the last 3 years. Next bill is Chapter 149. This is a significant piece of legislation, and the good part about that is that the policy folks have put out a pretty significant policy advisory. So hopefully most of you are up to date on what is happening with this piece of legislation. This was our big piece of legislation this year on teacher and principal evaluation, dismissal, and non-renewal. The big item was that there were trailer issues that we needed to accomplish in order for the proper implementation of this. And, you know, a huge hats off to Tom Pickrell, MESA's general counsel, as well as Jennifer McLennan, that did an unbelievable job in helping to take care of some of the legal issues as well as some of the drafting items on this. The provisions of this bill are retroactive as of July 1st, 2013. I'll talk to you specifically about the kind of trailer bill items that were needed for implementation, in that it still requires all teachers and principals to have an evaluation at least once. And there's been some confusion about evaluation versus observation. So every teacher and principal needs to have an evaluation at least once a year. But when it comes to observations, this was one of the issues that we needed to change, frankly, for a human capital issue to get through, in the fact that now if you are a continuing teacher, so if you've been employed there 3 or more years, and the observer comes in and is rating that person either highly effective or effective, there is no need to do a second observation unless that teacher requests it. So that should be a huge assistance to districts and really focus our time on those folks that need additional assistance. There's also a clarification that one of the incentives that we can provide to our teachers is multi-year contract. We want a clarification that that is not mandatory, rather a option for districts to do. Another issue that was absolutely integral is the use of data. As you know, the teacher and principal evaluation framework requires a foundation of 30% of quantitative data be included. And as you can imagine, there are different folks and different data that needs to be used in order for it to be a fair and valid evaluation system. So the legislation allows for a plan for the appropriate use of quantitative data. You can make distinctions between certificated teachers and those that don't provide direct instruction. It also makes very clear that we can use multiple years of data. I think that was always the intention, but we wanted to make sure that that was clarified, that in fact that is allowed. And also that you can limit the use of data for teachers who taught less than 2 complete school years, because we're not necessarily going to have the data plan there. And the other item that was clarified was that a governing board, in their efforts to define what inadequate classroom performance is, we allowed for a governing board to go above what the current standards of the performance classifications are from the State Board of Education. Now keep in mind that the governing board still must develop this definition with certificated teachers, but if they want to go above and beyond as a district, that's absolutely allowed and helpful. The two items that were kind of furthering the intent of the previous legislation, I'll just go into two items on that, is the first that if a teacher is given a preliminary notice of inadequate classroom performance, they must receive 45 instructional days, that's a change, 45 instructional days after issuance of that notice to correct the deficiencies, and then they also must maintain adequate classroom performance in those areas that were observed as being adequate. So we don't have the teeter-totter effect on that. I think that's a significant change and definitely the intent behind the legislation. And then the last item is that now talking about non-continuing or if a continuing teacher, so a teacher that's been employed 3 or more years, is designated as ineffective, so the lowest category, then that next year they come back as a probationary teacher and retain that status until such time as their evaluation becomes highly effective or effective. I think that was always the intention of the legislation. It was also what the State Board of Education put forward as far as their definitions of what should be an effective teacher in order to gain that continuing status. So this is, again, those are the main points on that. This is a significant piece of legislation. I think we've seen this, though, through our legal seminars, the policy updates. We've spent a lot of time on that. But again, Chris at the end will talk about some of the policy updates. But if you have any questions, please don't hesitate to let us know, because that was we spent a lot of time on that piece of legislation.
Okay, next one is House Bill 2441. Before we get into that, I just want to mention a little bit on House Bill 2500 that Janice just talked about. That was an awful lot of effort by the School Boards Association and some school districts and some of the other education organizations to work with the chairman of the House Education Committee and to try and get something that could get through the legislature, but also was something that would work for schools. So that one probably took more effort and more time than any other bill during this whole legislative session. The next bill is House Bill 2441, and Janice in the beginning talked about the effective dates for legislation, and this is an example of a bill that has an emergency clause, so it became effective upon the governor's signature. And basically it's another, I think, good bill in that it allows the Department of Public Safety to contract with an entity to provide electronic or inter-based fingerprinting services that would speed up the process for people to get their fingerprints on record and get them approved, and hopefully that would help that process, and hopefully DPS can find someone who will do that and it'll be effective.
Chapter 175 on trying to provide some accountability to the Empowerment Scholarship account. This piece of legislation came through from the Department of Education and the Goldwater Institute about trying to have some accountability for fraudulent activity in the Empowerment Scholarship Account voucher program, so that if ADE finds fraudulent activity, then it allows that ESA to be revoked if they're out of compliance with the contract, and for the treasurer to stop payments in that account. It does allow parents to appeal ADE's decision. I would say this is a positive piece of legislation on the financial side. I think it's very disheartening, though, that the other piece of legislation that was trying to find some academic accountability never made it through the process. So only the financial accountability went through.
Okay, the next one is Senate Bill 1103, charter school zoning procedures. The concept in this bill was in that last bullet point on there, that it was to make the process for charter schools more like the process for school districts, and basically it allows a charter school to use a third party as its representative, and it makes some other changes to the statute so it's more in line with what schools do in terms of getting permission and authorization to build schools in certain areas.
Chapter 182 on duty to report. This piece of legislation was an effort, I think, in a positive way to try to make sense of the duty to report and deal with some of the over-reporting issues that I know has been frustrating to districts as well as law enforcement. And so what this does is that a mandatory report is not required to report if the minor is in elementary school, the physical injury occurs during a typical playground activity at the school, during the school day, and that injury is reported to the legal guardian of the minor. And then lastly, that the school has to maintain a written record of the incident. And again, this is trying to deal with some of those issues that happen on the school playground that should be dealt with administratively rather than creating a report from law enforcement. On this item, we do have a commitment from the sponsor, Senator Griffin, to next year revisit that last item about maintaining a written record. We also don't want this to become an administrative burden in an effort to try to streamline all of the duty to report. At the same time, we also want to focus those reports that are of significant nature and ensure that law enforcement has the resources to do so. The last part of this bill is, frankly, specific from a constituent that really started this entire piece of legislation, is that if a governing board so approves, it allows the school to expunge a report from a student's file if the two items there are contained. This is session law, so this is only good for 1 year, and that's why I kind of say it's a specific incident that happened for a constituent of theirs.
Okay, next is House Bill 2347, tax levy bond costs. This is another good example of where the education organizations, school districts, and the people in the bonding firms work together to try and make it workable. In the beginning, it wasn't. But basically, this is an Arizona tax research effort to limit what can be included in the levy, secondary levy for bond costs, and basically what the districts are allowed to do is to levy, obviously, for the principal and interest, including a reasonable tax delinquency factor. And the last item was added after different groups looked at it, and basically that's arbitrage, the 35-512. So if we ever get back to the point where there are where arbitrage is a factor in terms of districts earning interest more than the interest that they're paying, they can levy for the expenses of doing those reports and any arbitrage fees. So that's House Bill 2347.
In Chapter 189 on teacher employment contracts, electronic signatures, this basically allows boards to accept contracts with electronic signature on it. I know some districts are already doing this, so this is good. This will make it legal to actually do so. It does require the electronic contract to be submitted to both the certificated employee school and district email. And then it also requires it be sent to their personal email. But I will say the impetus on the personal email is on the employee. The employee, and this is articulated in the legislation. The employee is required to put their personal email on file with the human resources if this provision is to be implemented. It also requires school boards to provide validation that the contract has been transmitted. So that's just keeping a copy of the email when these contracts are sent out. Next bill is Chapter 191 on superintendent contracts. This is a pretty simple bill revising the time frame of when a board can extend or renegotiate a superintendent's contract from the May of the preceding year to just no earlier than 15 months. This came about when a superintendent was brought on board during a time frame that didn't allow that 15 months to actually be extended. They were having to renegotiate at a shorter amount of time. And so this just says whenever you are hired, you can then renegotiate that contract no earlier than 15 months before that contract expires.
Is that this is one that Janice and I fought over as to who would be doing it, and I guess I lost. But anyway, it's Chapter 195, Senate Bill 1100, and that continues the Arizona State School for the Deaf and Blind for another 10 years. Janice really owes me now for taking on the responsibility for explaining that bill. I should pay more attention. Chapter 229, House Bill 2499, again, relates to JTEDs. And as it said early on, the Joint Technological Education Districts did very well this session in terms of some of the things that they wanted to help them operate in a more effective and efficient manner. We all talked about the 91% funding being eliminated for most. But basically a couple of things here is there's always been the issue between centralized campuses and satellite campuses, and the centralized campuses like the East Valley Institute of Technology have a higher funding level. And the JTEDs worked out a plan with the legislature that in a number of places they can operate centralized campuses now at the higher funding level if they lease the space rather than before it was they actually had to build and own the facility. But it allows under certain circumstances for those centralized campuses to exist in other areas of the state. For accommodations, school students, before they were not allowed to participate in JTED programs, now they are. And centralized campuses, you can see the concept is they want those programs to be open to all students who reside within the JTED, not just students who reside within that particular school area. So this is a good thing, and I'm sure the JTEDs will be working with their local districts to better implement this and explain it to people, but this is a very good thing for both the school districts sending students to the JTED and for the JTED.
Chapter 240, this is on CPR training. It allows, beginning in the 2015-16 school year, students in grades 7 through 12 to be provided with one or more CPR training sessions through the use of psychomotor skills in an age-appropriate manner. There was some work done with this with the Heart Association as well as other interested parties to make sure that this was an optional issue. So this is all optional if you choose to do so. There's also an opt-out for a student who chooses, or a student who chooses not to be a part of it, or a parent who chooses not to have their child be a part of it. And last, it allows districts to receive in-kind donations of materials, equipment, and services. I know that many folks partner with their fire departments on some of the dummies for CPR training, as well as with the Heart Association. Next bill is Chapter 243. This is a similar bill to the previous one, the fact that this one is voluntary as well, and I'll kind of go through why it is voluntary. But first, it requires school districts and charters to stock auto-injectable epinephrine at each school and establishes other requirements regarding those. So this is really coming about with the whole food allergy issue and the fact that more and more kids are succumbing to food allergies and wanting to make the educational place more safe. However, one of the concerns is that this legislation required each school district and charter school to stock 2 juvenile doses and 2 adult doses of epinephrine at each school. And that becomes challenging, both for the fact that it costs a little over $100 per 2 doses, but also that there's only a 15-month shelf life for epinephrine. And so the fiscal note on this piece of legislation came up to about $700,000 a year for schools to do this. And so what was provided in the legislation, that if the state does not provide that appropriation, then it is voluntary for schools to do so. And it's voluntary for schools to not only stock the 2 juvenile and 2 adult doses, but it's also voluntary to provide the training to administration as well as the school site personnel. If the school does choose to do this, it requires, or it does provide civil immunity for persons acting in good faith in the administration of the epinephrine.
This is Chuck Essigs. I think that the ASBA ought to give Janice an honorary medical degree, because this session she worked on a number of these bills and got all the medical terms down and pretended she was a doctor. But anyway, they ought to give her some reward, or some kind of reward for that.
Yeah. Rest assured, I will not be practicing medicine. I think people will be too scared. Chapter 250 on this is the negative bill on the Empowerment Scholarships account, because we saw the expansion of this, and as was mentioned earlier, we're still in litigation with whether Empowerment Scholarship accounts are even constitutional. But this is now the 2nd year in a row that we've seen the expansion of that account. regardless of the court case that we have. But it now includes kindergartners in the eligible group of persons that are eligible for the voucher, and it now includes 90% of the sum of the base support level, as well as the additional assistance for that student if that student was attending a charter school. So two things to note about it. Obviously, it's an expansion to allow kindergartners, but it's also going to be an additional cost to the state because of the use of charter school additional assistance. There was varying degrees of what that dollar amount would be based on the fiscal notes, but it will, I think we can be confident to say it will be additional general fund dollars going to this program.
Okay, next bill is Chapter 251, Senate Bill 1447. This bill, near the end of the session, a number of things got added to it that had been vetoed. The first thing is a good example. Charter schools may choose to provide a preschool program for children with disabilities. That was in another bill that had gone through the legislature and was vetoed. If you remember, the governor, when the Medicaid bill was not making the progress she thought should be made in the legislature, she started vetoing bills until they started to work on the budget. That bill did get vetoed, but it got added into 1447, so charter schools may provide preschool program. I believe there was one charter school that was requesting this. The next one will help JTEDs and will help charter school students. Basically, the charter school students who reside within the boundaries of a JTED can participate in the JTED program in the same manner as district students. ADE is required to evaluate any school that has been assigned a letter grade of F. I believe that was in one of the other bills that had gotten vetoed.
I'll just jump, if I can just jump in on that issue too. This is one issue that the Department of Education has been trying to codify their administrative or regulatory processes into statute. And so in addition to ADE being required to evaluate that school, there's also a process of how you get out of school improvement. So I think that's actually a really positive measure for schools in showing that, you know, schools should not stay there forever. There's a process of getting out, and that the department's also committed to getting schools out as quickly as possible.
And the last item that we haven't discussed with you on this bill is that the Director of the Department of Administration or designee, there's an Arizona Department of Education Data Governance Commission, and that person was added to that commission. Next bill is Senate Bill 1447, and a couple of the items in there. There was a bill going through the legislature that was eliminating one of the bus reports that school districts have to provide to the Department of Ed. That was in a bill that got vetoed, so that was added into 1447. They did put in here certain repayment options to help Red Mesa High School manage the repayments and over expenditure issues with the Department of Ed. Requires the ADE data governance. Remember, we talked about that was expanded by adding another individual to ensure that adopted guidelines for the Department of Ed reduce duplication and administrative requirements. And this one, I think, is more of a technical change. For some reason, the law used to say that JTED students were not eligible for state funding if they were over age 22, and now it's more consistent with everything else where they're not eligible if they're over 21 years of age.
Chapter 252 on personal finance, it requires the state board to prescribe competency requirements for personal finance for high school graduation. And basically the personal finance is already somewhat included in the economics requirements for high school graduation. But that the state board needs to specifically put personal finance into that item. I don't see that being a huge change in the competency requirements. I think it's just an additional item that frankly is already being accomplished through the economics credit. It also prohibits the state board from requiring a separate personal finance course for high school graduation. And there was a lot of work done by Representative Carter on this to make sure that this was not an additional high school graduation, but that if a local school district wanted to require that, in addition to what the state requires, that was still allowed, but it wouldn't become a state requirement. It would just be part of the current competency requirements. And the last bill, Chapter 253 on FERPA. A lot of work was done on this, and appreciate the efforts of Senator Yee to work with us on this legislation. And what has pretty much happened is that this codifies an administrative process in order to alleviate any FERPA violations that may or may not be happening. She had received some complaints from constituents as well as others about folks that were giving personal information about students that was in addition to the directory information that was signed off by parents in the beginning of the school year, and being provided to different health professionals without notification, specific notification from their parents. So what this bill does is establishes the notification process regarding knowing violations, and please keep in mind it's knowing violations of FERPA. So any person that suspects that a district or charter school has violated FERPA first must notify the principal of the charter school or the school district superintendent to address the issue. Both of those persons have 60 days in order to satisfactorily resolve the matter. If the complainant does not feel that that has been resolved satisfactorily, they can file that complaint with the superintendent of public instruction. Interestingly, a lot of complaints, I shouldn't say a lot of complaints, but complaints that do come in already are coming into the superintendent of public instruction. So they're already kind of dealing with this issue. If the superintendent notifies the district or the charter school to try to address the issue, and if they feel that this still is not complete, it does not mandate, but allows the superintendent of public instruction to inform the Family Policy Compliance Office of the U.S. Department of Education of a possible violation. I want to thank Senator Yee. There's a lot of work done on this, and really appreciate, too, that there was a financial penalty that was previously on the bill that would have allowed the state board or the superintendent to withhold up to 10% of state funds. That was taken off in a compromise. So this is now an administrative process to try to ensure that school district and charter school personnel know that it's fine to go ahead and offer these items. They just need specific approval before doing that. And so that kind of wraps up the significant pieces of K-12 education legislation. And we'll now turn it over to Chris Thomas, ASBA's General Counsel and Director of Legal and Policy Services, who has been busy not only with all of the law conference items that will be coming up, but also trying to get out some significant policy changes. Chris?
Thank you, Janice. Want to let you know about some of the policy changes that have already come to you and some others that will be coming to you. Janice and Chuck did a great job of covering the bills. Many of these will then be reduced to policies that you will adopt as your own. But what you should know is that a lot of these things, when they were directing the Department of Ed to do something or directing the State Board of Education to do something, you're really not going to see any policy changes because it's not changing the way you do business. It's sort of things that are happening behind the curtain. So not every bill will result in a policy change. But I want to remind you of a couple things you hopefully have looked at and adopted. Our first group of advisories went out in May. And these are policy advisories 468 through 472. They deal with several things. One, the payroll deductions bill from a couple of years ago. This was the bill that required employees to approve a payroll deduction each and every year if they were going to give money to their union. There was an injunction. It was a temporary injunction that was put on that bill by the U.S. District Court. That injunction was made permanent. And as such, we have changed our policy recommendation in that area, and that is now something that we've pulled all together. The Policy Advisory 469 deals with emergencies and how you handle them. I advise you to take a look at that one. Another one that was not statutory in nature, but we've advised Policy Advisory 470 has to do with your early retirement programs and whether or not they foster age discrimination as seen by the Age Discrimination Loss Act. We've asked everybody to, if you have our model policy, we've changed that model. Not many do, but if you do have a policy that provides for an early retirement program, to discuss with your counsel or have them take a look at that to make sure that it does not foster age discrimination. 471, Policy Advisory 471 dealt with graduation requirements. It was a minor change. The bill that Janice mentioned that was substantial, House Bill 2476, which dealt with isolation rooms for general population students, was dealt with in Policy Advisory 472, which also went in that packet of advisories. So hopefully you've looked at those and have moved those towards adoption. The next group of advisories went out in June. These were Policy Advisories 473 to 475, just only 2 weeks ago now. These are the advisories that encompass all of House Bill 2500 and the implementation of those. A couple of things I want you to know about this. One is to highlight what Janice already mentioned, that this bill has a retroactive date of June 30th, 2013. And so to sort of move things along, we've encouraged districts to utilize their policy BGB, which allows them to declare an emergency and to adopt these policies in one reading, as opposed to going to multiple readings to adopt the policy. If you have any questions about how to do that, call Renee Watson. She'll talk you through that. She's our policy services technician. In addition, another thing that's unique about this group of policies is that they need to be adopted in their entirety if you're going to be fulfilling our model. There were so many changes with House Bill 2500 that we didn't think it was right to sort of line out things and add things because there wouldn't be much left. So we completely redid them, and so we are recommending that you adopt them as new policies. It makes it easier for you, but if you have local changes about those, local set that deviates from the model considerably, you will have to look through those and decide what local things you want to keep in your policy. If you need any help on that, we do have a lined out version that we do have. If you want to take a look at it, you can contact Policy Services and we'll provide you a copy of that. The next batch of policies we're slated to try to get out by the end of July. They cover many of the issues that we talked about today that Janice and Chuck covered. Not a lot of substantive things, but nothing compared to the first dealing with House Bill 2500 and the isolation room one. But there will be a few changes that will be coming out by the end of July. A couple things I want to mention though as well is that I want to mention we're going to be talking about a new services that we're providing. We're revamping a lot of what we do in policy services, going to a web-based system. It's going to allow you to more seamlessly integrate with your board document management service, also allow you to use your tablet. So it uses HTML as its language, so it's going to be seamless for you that are going to a higher tech system. And even for you that don't use that system, it'll be easier for you to use. We're going to talk about that at our county meetings coming up. So we'll have a standalone early session to talk about those changes. So you'll want to put that on your calendar. Another thing to put on your calendar is the law conference, which Janice mentioned. Different configuration this year. We are having pre-conferences on Wednesday the 4th, and the actual conference will be full-day sessions on Thursday, September 5th, and Friday, September 6th. And we're expanding our offering of breakout sessions. We're going from essentially 12 or 16 breakout sessions to full 28 breakout sessions with no repeats, so a lot of content. And I also want to highlight those pre-conferences. We will be dealing with 5 different pre-conferences: the Law School for School Leaders program, a session on open meeting law and public records designed primarily for board members, a session on school finance for the non-financial expert, which is also designed for board members. We'll have, for your administrators out there, we will have a full day or half-day session on special education law, and then another half-day session on teacher and principal and evaluation. The great thing about this is that if you pay one price, you get all of those conferences that you can attend, and you can get materials for all of them. So definitely want to commend to you the law conference. Put that on your calendar. The hotel and registration will open on July 15th. So again, you'll want to put that on your calendar because those rooms at the Calback Inn where we're having the conference this year do fill up quickly. So with that, turn it back over to Janice and Chuck.
Chris, could could you just give a brief update of the Prop 301 inflation lawsuit, where that stands now?
Sure. The Supreme Court has accepted review of the Prop 301 lawsuit. We were hoping that they would not accept the review and the decision would stand, but they are accepting the review on the singular issue as to whether or not the voter protection provisions of the Arizona Constitution extend to what amounts to an instruction from voters to the legislature. The inflation provisions of 15-901-01 essentially instruct the legislature to adjust the base level in future years. So it's not something that, it's not a law where the legislature is changing that law, which is, the focus of the Voter Protection Act. It's, in other words, when the people have voted for the legislature to do something in the future, is the legislature bound under the Voter Protection Act to follow that instruction? And that is before the Arizona Supreme Court, and we don't have an argument date for that one yet. We have an argument. Oh yes, we actually do. We do. July 23rd. We have an argument for that. We have so many lawsuits going on right now. It's kind of hard to keep straight. But yes, absolutely, we do have. That is July 23rd, and we hope to get a decision very quickly out of the Supreme Court, so we finally get resolution on that case.
Okay, thank you. Well, we have a number of questions, and the majority of them probably need to be submitted to the Department of Ed or the Auditor General, or they're in the budget forms that you sent out. So what we will try and do is I'll look through some of those and see if I can get some general answers from the Auditor General or the Department of Ed. But we do have a couple that we can probably look at. The first one, we probably don't have an answer right now, but we'll follow up on it. It basically, on the soft capital monies that go into M&O or capital, the question is, can districts wait until the end of the encumbrance period when they know specifically what that number will be? And we'll check that one with the Department of Ed and the Auditor General and give you an answer on that. Rollover, we have a question on the rollover for small districts. Will we receive the rollover for a full year of state equalization funding starting this fiscal year? What happens for this upcoming fiscal year 14, if you're a district with less than 600 students, you'll get your full payment. So the current law calls for you to receive a 12th of your state aid each month. And if you're a district that has less than 600 students, you're no longer subject to the rollover, so your payments each month will be the full amount without any rollover taken out of it.
Question on the base level increase for inflation. Does it have any restrictions on the spending, or is it up to the district to designate the spending? It is completely up to the district to designate the spending. In the final budget bill, it did also include, it basically said these monies, are to be added to the base support level for inflationary increases, including Common Core implementation. So the phrase including Common Core implementation is in the legislation. However, how you choose to spend those monies is still the same for a local governing board to decide.
Okay, another question about the payment schedule, and again, when will that come out? I assume the Department of Ed will put something out, but what we've been told is that they'll take the rollover out of each monthly payment on an equal amount, so you won't get smaller amounts taken out one time and then larger amounts other times. That basically, once your payment schedule is determined, the rollover amount for your district will be taken out in equal payments, so each of your 12-month payments will be the same during the school year.
So please clarify, pro-con statements still allowed by the board for both bond and override ballot measures? Yes. In House Bill 2156, it is clear that as long as the governing board as an entity can still submit a pro-con statement.
Okay, then another question is the JTED age limit of 21. Is that based on enrollment date? We'll have to take a look at that, and we'll get an answer out once we check with the Department of Ed, probably how that works for the change in the JTED. The next question is on charter schools. What are your thoughts on converting to charter schools to get the additional funding? probably should have mentioned that. I had a note, but I skipped over it. That moratorium, which was in some of the budget proposals early on, that would have basically put a moratorium on school districts converting their schools to charter schools, was taken off. So there is no moratorium. I think on our website, if we don't have it, we'll put it on there. There's a good report from, I believe it's on there though, from the Joint Legislative Budget Committee that shows how much it would cost in their projections of districts converting their schools to charter schools. A very small amount for next year, because the first year you don't get a lot of additional funding because the students who are there this year are still counted to the old system. But I believe in the third year it was up to like $60 million. So the question is, will that practice continue? There will obviously be a question, how much can the state afford? But right now there is no moratorium, and districts are converting their schools to charter schools. I believe you had to have a deadline that the Department of Ed set out to when you were going to notify them, which is maybe already passed for next year.
Next question is about, if the district didn't spend the Move On When Reading monies last year, do they have to put it in fiscal year 14? Also, are we really getting additional funds for Move On When Reading for fiscal year 14? If you did not spend your monies from last year, you can carry those forward into the next year, and that was specifically done because the first year of implementation, the State Board of Education was kind of inundated with, they had to look through all of the applications and then approve the CD and F school applications. So they knew that they did a great job, but they knew it was going to be later that those monies would be approved. So yes, budget that into fiscal year 14, and as far as this year, we did receive a continuation appropriation of $40 million. So $40 million was appropriated last fiscal year, and then that has been continued for another $40 million this fiscal year. And keep in mind, this next year will be the first time that we actually have third graders that we will be determining whether they fall far below and have to have an intervention or retention.
We just got a comment in from someone, and I think that it is true that the deadline for submitting applications for charters to the Department of Ed was June 30th, which is, I know it just recently passed. The other thing on the soft capital fund going away, in earlier discussion we had with the Department of Ed, and unless they've changed, is any soft capital money that you would move into your maintenance and operation budget for next year, which you're allowed to do, any of the budget capacity, that would count against your 4% limit. So it would be, you can certainly move budget capacity and soft capital into your operational budget, but be careful that any that you move over there would count against your 4% limit.
Another issue is, I read that House Bill 2500 prohibits walkthrough data from being used in the teacher evaluation. Is that correct? Actually, it is correct that you cannot use walkthrough data. However, that was first addressed in House Bill 2823 from last session, that it does have to be an uninterrupted lesson for the observation. And keep in mind, you know, we've had, I think that's a significant issue that's also included in our policies, the difference between an observation and an evaluation. The observation needs to be an uninterrupted lesson. The entire evaluation includes the observation as well as the data component.
Right. I think one of the things as well is that we wrote the policy to make sure that you have those full uninterrupted lessons for the two observations. However, we also gave you some discretion that if you're going to go above and beyond that, so you've done your two uninterrupted lesson observations, and you wanted to add formal or informal evaluations beyond that, or observations beyond that, you can. So I would say walkthrough could be used as long as you've got the other two that you've done in an uninterrupted lesson.
Next one is, if high school students have met or exceeded on their aims, will they be required to take the PARCC exam in order to graduate, or will they be grandfathered in? There's a lot of work being done on that question. It's a great question. At the last State Board of Education meeting, that report is also on the School Boards Association website under educational reports. The State Board has open rulemaking on this issue, and there is continued conversation. So there's not an answer yet about what it will look like, except that no, it's on the state board's radar screen. Part of the issue of why there's not an answer is that even though the park assessment is saying that it will be implemented in 2014, 2015 as a computer-based system, it's pretty much known that there's going to be a pencil paper test probably for the first 2 years. So with that in mind, there's still some uncertainty about what's happening at the park level, making it difficult for the state to determine what they're going to do with the implementation as far as how it affects graduation. I will say for this year's 10th graders, just under, for legal issues, there's going to have to be the opportunity for retesting because this is how those 10th graders are entering the system under the Ames rules, and so there will have to be other opportunities for retesting for that graduation time. What's unclear is whether there will be a gap of, quote, no end-of-course testing or no Ames for kids to graduate, or if there'll be some transition item that will be allowed. That's very much on the state board's mind, but there's been no decision made on it.
Okay, we have a question about the signatures for the referendum to put a hold on the increase in bond capacity. Just to basically review that, there's been 2 referendums filed with the Secretary of State. The first one would be to, if they get enough signatures, to delay the implications that are there for changing the law for the Medicaid expansion. And if they get enough signatures, according to some people, that means that it would not be put into practice, and it would have to be on the election in 2014, whether the voters wanted to approve it or not. That same referendum process was used to file paperwork to do the same thing with the increase in bonding capacity. And basically what that says is if by September 11th, 2013, if they get 86,405 ballot signatures, now obviously you have to get quite a few more, quite a bit more signatures to get 86,000 ballot signatures. But if the Secretary of State certified that there were those ballot signatures, then the increase to the bonding capacity would not be implemented. It would go on the ballot in November of 2014. I think, and Chris might want to comment on this, I think the governor's office has some issues with whether they can do that on the Medicaid expansion because it's actually part of the budget. I don't know if that same argument would be made on the bonding capacity.
Yeah, the question is whether or not, because it's part of the budget, can that be referred? Because it's an emergency measure meant to allow the government to operate. And so the governor's position is that, this is not something that can be referred. There is another one, another referendum, I think it's not on a bill, obviously, that we covered, but I think it's House Bill 2305 that has to do with some election law changes that are fairly controversial.
Go down a little bit. I think there's something on 1204. So you stated that the Senate Bill 1204 was generated by a grant from the Charter Association. That is the basis for the new application. Now let me clarify. So the kind of overhaul of the application renewal process with the State Board for Charter Schools, the Charter School Association received a national grant in basically taking a look of our chartering laws and seeing how well they stand up for accountability purposes, academic purposes, those items. And many of the findings that came out of that grant were part of the legislation that was in Senate Bill 1204. And so it's not the basis for the new application per se, but it was a basis to say what's good and bad, to be just really simplistic about it, but what's good and bad in Arizona charter school statutes versus what they're seeing nationally and what kind of accountability that they want.
The other question, is there any new funding for Common Core implementation? There is not funding specifically for Common Core implementation. The decision at some point was to use the inflation funding factor to increase the funding for schools.
And that, just to kind of expound on that just a little bit, like Chuck said, there's no specific funding for Common Core implementation, but you can use that inflationary funding. But I think as we move forward, that's probably a little more commentary, but as we move forward, we have articulated to various groups that really are being supportive of Common Core implementation, whether they be the Chamber of Commerce, the Governor's Office, others, that while they're very supportive of implementing Common Core, we are being very clear, too, that you can't spend $1 twice. That the reality is that the inflationary money was what voters had voted on, and that school districts are using those resources as the voters intended. At the same time, Common Core implementation needs to happen. Some districts have already fronted that money. Others are having to address it, but one doesn't take the place of the other. Both of those need funding. But I just kind of say that because there is going to be some conversations, I think, that we're hearing if those monies are used differently, but know what our messaging has been to various entities.
Could we have a follow-up question on Senate Bill 1293? That was the one for the pilot program for outcome-based education. And what will happen on that is the State Board of Education is to solicit a request for information regarding some of the parts of that program from districts, I think, by October 31st, 2013. And applications are due to the State Board of Education by January 1st of each year. So there will be some time, and I believe it looks like the Department of Ed will have to put out more detailed information about how the pilot program for 1293 will work. It's actually called a simulated outcome-based funding pilot program and allows school districts to submit applications. So I'm sorry, we don't have answers for that. We'll have to wait to see what the State Board of Education puts out on that. And do we see any others?
See another one about, where is it? As a school board member, if I'm not supportive of student confinement, can I vote no, or do I violate state statute? It requires that a governing board has to develop a policy. That policy, if you don't have a policy for confinement as a disciplinary measure, that's something that you would need to have, obviously your entire board approval for. But it's saying that, though, if you do use confinement as a disciplinary measure, it has to meet the standards outlined in law.
Right. Yeah, you can always be more restrictive. I mean, if the state law is to restrict isolation rooms and to allow it under certain circumstances, a board could decide to not use them altogether. That would be a local determination. So yes, that would be, that would be an option to you. Now, what you just can't do is violate the state law and be more permissive than what the law requires.
And the other question on the move on when reading or move on when ready on the carryover money, the money has to remain in that move on when ready program. And I do believe that the Department of Ed also says that that would be counted against the district's 4% carryover. But whatever money you didn't spend on move on when ready, you have to keep it in that program when you submit your application to the State Board of Education.
How will information regarding the safety grant applications be communicated? Is this to take the place of the state's current safety grant? So I'll start with the last question first. No, this does not take the place of the current safety grants as they relate to school resource officers. Those continue, as Chuck mentioned, that $7 million that comes from the Prop 301 monies will continue. This new safety grant, there's an outline of what needs to be considered in those school safety grants. So that $100,000 pilot program is to be administered by the Department of Education. So I'm sure that they're working on that, and they will communicate out what the processes and procedures are going to be in order to apply for that $100,000 of a little over $3 million. There's also that requirement that 25% has to be on security hardware. Again, I would expect that coming from the Department of Education. We are continuing to be in conversation, but what our initial conversations are is that remaining money would augment that current $7 million that comes out of Prop 301 for school resource officers. And what they're trying to do is start getting through that waiting list of districts who want school resource officers, want that additional state assistance, but can't afford to do so. So that's part of our initial discussions. We should be hearing more in the next few weeks of how that will actually get rolled out.
I think that's pretty much the questions that we're answering at this point in time. We will look through those answers and see if the Department of Ed or the Auditor General can help on some of those that are more specific. But I would encourage the districts that have specific budget questions to contact the Department of Ed or the Auditor General's office so you get the correct information. I do want to thank the Lyle and Chris Cable from the Department of Ed for really working hard and working late into the night many times to try and get those budget forms out to schools. It was real difficult for them as it was for everybody else by the legislature finishing up so late in the session. So I do appreciate their work. And that's it for today, and thank you very much for participating in the webinar. We will record this and post a recording of it on both the ASBA and the ASBO websites. Anyone have anything else to add? Thank you for participating. Jeff, thank you for doing your legislative summary and posting it online. So